What level of suspicion do police have to extend a traffic stop and look into a car? To find out, you have to read People versus Thomas, but it's 17 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Thomas. The citation for this case is 2024 New York Slip Opinion 03319, published by the New York Court of Appeals on June 18th of 2024. The issue in this case is whether the police unlawfully detain an individual for too long after a traffic infraction investigation, and if doing so results in suppression of the contraband recovered as a result. To appreciate the context of this case, I think the helpful background is two things. First, that there's something called a DeBoer analysis. DeBoer is the name of the case. It talks about different levels of street encounter. There's 4 levels in New York. The levels are number 1, objective credible reason, and that allows the police to approach for information. So if the police have an objective credible reason, they can approach a civilian and start talking to them about things like if there's a missing child, if there's a missing dog, if there's some situation they can approach and start speaking to individuals. Number 2, level 2 is founded suspicion that criminality is afoot. If the police have founded suspicion that criminality is afoot, they can then go a little further, which is the common law right of inquiry. They can ask more pointed questions. They could say, they can ask questions about criminality with respect to an individual. That's level 2. Level 3 is reasonable suspicion that a crime has been committed. And for that, they can now stop and frisk. If there's reasonable suspicion that a crime has been committed and the person committed it, they can stop and frisk that individual. And number 4 is probable cause, and that is arrest. If the police exceed the level of suspicion they have, if they go beyond what they're allowed to do based upon those 4 levels at any given time, then it's unconstitutional and it can be suppressed. Okay? The last thing you have to know about background is that the standard for detaining an individual after a traffic infraction is reasonable suspicion. So they can deal with a traffic infraction and resolve it, but if they hold them after the investigation for the traffic infraction is over, they have to have reasonable suspicion or greater, or else it's an unconstitutional violation. All right, what are the facts in this case? The facts are the defendant, in this case, Mr. Thomas, is on lifetime parole for a drug violation, with several release conditions, including a curfew condition, you can't leave the county condition, you can't leave the state condition, you have to talk to the parole officer and answer his questions condition, a lot of conditions on this parole. He was not allowed to leave Chemung County. Now, the defendant was observed by an off-duty police officer driving outside of Chemung County, in fact, in Pennsylvania, in a different state, by an off-duty police officer. That off-duty police officer recognized the defendant, knew he was on parole, and then called back to his station house and said, hey, I'm off duty, but maybe you guys want to look into this. He's off curfew, he's out of this county, all these things. So the police then post up a car near the highway by where the defendant lives, because he has to come back home, and they post a car there to see when he gets off. They watch him get off the highway, they follow him until he does not come to a complete stop at a stop sign. So now they have him on a traffic violation of the vehicle and traffic law because he failed to come to a complete stop at a stop sign. They pull him over. He pulls over at his house. And this is around 9:20 p.m. He then admits to the traffic infraction. He gives his license and information they requested. And at that point, they start asking him questions about where he was, who he saw, where he's been, which is unrelated to the stop sign investigation, to the stop sign traffic infraction. He gives inconsistent or information that's not accurate. They know he's not accurate. So then they ultimately threaten to call a canine officer. They want to search his car. He refuses. They ultimately call his parole officer, who arrives around 9:50, which is around 9:49 to 9:50, which is more than 20 minutes after the initial traffic infraction investigation started. He refuses to answer his parole officer's questions, which is another violation, and refuses to consent to the search. The parole officer searches his car and recovers 2,000 glassine envelopes of heroin, right? A crime. He's arrested, and ultimately he moves for suppression, claiming that the police exceeded their authority when they searched his car with a warrantless search. The judge denied suppression, saying that there was founded suspicion of criminality that justified the continued detention. The defendant was ultimately convicted of criminal possession of a controlled substance in the 3rd degree. He appeals. The appellate division affirms it based upon that same argument that there was founded suspicion. He then appeals to the Court of Appeals, and here the Court of Appeals says they analyze the facts and information we just gave, and they say this was wrong. Why? Because founded suspicion is the wrong standard. They need reasonable suspicion to believe that a crime is committed and the defendant committed it in order to extend this already resolved traffic investigation. So here they say the county court, the original trial judge, applied the wrong standard. The appellate division applied the wrong standard. So they reverse the conviction and remit it. They send it back to county court to apply the correct standard of whether there was reasonable suspicion. Not probable cause, but reasonable suspicion to extend the traffic stop so that they can then search the vehicle. That's the majority holding. There is a dissent from Judge Rivera. She says she agrees with the facts and the law, but she would just answer the question directly. She says, based upon the record here, there was reasonable suspicion to believe that the defendant had committed a violation and the search was proper. She would affirm what the ultimate result is, and that's the case of People versus Thomas. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.